All right. We'll start with your matter, Mr. Martin. Appears to be Ms. Harvey. What's the announcement in Ms. Harvey's matter?
Your Honor, I haven't had an opportunity to examine the petition, and I'd like to do so and then confer with my client before I announce, if that pleases the court.
Your Honor, it's my understanding that this is an old drug court case, and it's going to be before Judge Mason.
It's going to be before Judge Mason and not before me?
Yes, Judge. She was an old drug court case, and per our policy, if it's an old drug court case, then it goes through drug court proceedings.
Okay. Well, then I guess that takes care of that this morning, so we'll transfer it over back to Judge Mason for him to hear it.
Your Honor, I have filed a motion for bond. Would the court hear that, or would that be Judge Mason also?
That's going to be Judge Mason as well.
All right. Thank you, Your Honor. May I be excused?
You may be.
Yes, ma'am.
If you call Officer Stanley, I give you the officer, or you send me an email, I give you the officer for Judge Mason's courtroom. And you
okay. Fantastic. Thank you so much.
No problem.
Have a good weekend, Your Honor, everyone else.
You too.
Thank you.
All right. Let's see, I don't believe Mr. Coles has joined the call yet. What's the announcement in Lewis Gant?
Judge, I represent Mr. Gant. Mr. Gant was supposed to have been received in drug court just this week. I received at the staff and information concerning Mr. Gant's new referral to Veterans Court. Drug court thinks he'd be better off in Veterans Court. I've explained that to Mr. Gant. He's willing to go to Veterans Court. So we would ask for another continuance, Judge, just to get him on board. I'm not sure exactly where it is in Veterans Court, whether he's been formally referred or not at this point. I just got the information this week about that.
We'll remove him off the calendar for 30 days and then just keep us apprised if it's still in the process.
Okay, thank you.
What about State versus Armonte Johnson?
Which I believe we're going to have a full stipulation on that, as I understand what the offer is on the case.
Okay, or is he resolving his pending charges?
Those are not being prosecuted at this point, am I right?
We're going to withdraw for purposes of this hearing.
Okay. All right, so it's going to be a full stip?
Yes.
All right, Mr. Johnson can come to the podium. And if the Clayton County Court will unmute for me. Thank you. All right, thank you. Good morning, Mr. Johnson. You're here this morning for the purposes of a probation revocation hearing. It's my understanding that the state is withdrawing the criminal law violations, and as a result, it's going to be a full stipulation. You are represented by Mr. Ellis as your attorney. And Mr. Ellis, does he waive his right to be in my physical presence for the purposes of this hearing?
Yes, he does.
All right, will the state please place the violations on the record?
The defendant has violated the terms and conditions of probation in the following particulars. He's failed to pay his order, and that the defendant is currently $1,987 in arrears, making only one payment of $50 on January the 11th of 2020. He's failed to avoid injurious and vicious habits, and that the defendant tested positive for marijuana on or about December 13th, 2019. He's violated one of the special conditions to not possess a firearm while on probation, and that the defendant has recently been arrested for the charge of possession of a pistol.
And Judge, that the special condition of not possessing the firearm will be withdrawn too, because it's associated with the new criminal law violation.
All right. Knowing that that's been withdrawn, is that your understanding of the stipulations to violations, Mr. Ellis?
I'm sorry, Judge?
Is that knowing that they are actually withdrawing the special condition, because that also involves the underlying criminal charge? Is that your understanding of the stipulations to violate?
That's exactly it. Yes, ma'am.
All right. Therefore, I will find by preponderance of the evidence that he has violated his probation. What is the state's recommendation?
The state's recommendation is to release him on time served and to restore him to probation.
Okay, and to report within 24 hours?
Yes.
All right. Sir, I will release you on time served. I'll require that you are to report to probation within 24 hours of your release and continue reporting on probation. Do you understand that? Anything else on behalf of your client, Mr. Ellis?
No, ma'am.
All right, thank you, sir. You may be excused. All right, Mr. McKeithen, you're on a little early, but we'll go ahead and take you. Deputy, is Benning up? It's on the 10 a.m., but is there any chance he's up right now?
Let me check, Judge.
All right, thank you. All right, what's the announcement in Benning, Mr. McKeithen?
Judge, after discussing with probation, we're going to go ahead on and proceed with a stipulation and resolution today.
Okay, so it's a full step and resolution?
Yes,
All right.
ma'am.
Okay, State. Good morning, Mr. Benning. You're here this morning for probation revocation hearing. You're represented by Mr. McKeithen as your attorney. For the purposes of this hearing, Mr. McKeithen, is he waiving his right to be in my physical presence?
Yes, ma'am.
And it's my understanding that this is a full stipulation. Is that also correct?
Correct.
All right, so please place that on the record.
Judge, it's Laura Jansen, and if I may ask Ms. Stanley to place it on the record, I'm having trouble reading my computer screen.
Okay.
I apologize.
That's all right.
Judge, the state will be withdrawing the 8/25/2019 criminal law violation and proceeding on the July 23rd, 2020 violation of criminal law, which the defendant committed the offense of willful obstruction of law enforcement, fleeing and eluding misdemeanor, possession of marijuana less than an ounce, and giving false information, open container, and speeding, all in Clayton County, Georgia. Failure to pay. The defendant is currently in arrears, but as of today, his family has been making payments towards his monies, and he should be almost current. Violation of special conditions to complete 100 community service hours and theft prevention. He has failed to provide proof of completing special conditions.
All right. Is that your understanding of the stipulations, Mr. McKeithen?
Yes, ma'am.
All right, sir. Therefore, I will find by preponderance of the evidence that you have violated your probation. What is the state's recommendation?
To revoke 30 days to the Clayton County Jail. Upon service of that time, the defendant is to return to the original orders of probation with the added special condition that he get alcohol and drug evaluation and/or treatment and report within 24 hours.
All right. Sir, is that your understanding is the stipulation, Mr. McKeithen, as the punishment? Mr. McKeithen, was that the agreement as to sentence?
Yes, ma'am. And Judge,
All right.
he's been in since July the 23rd, today being the 21st. I think today puts him at 29 or 30 days.
All right, sir, I will revoke 30 days to serve. Upon the service of that, you are to return to the original order of probation, report within 24 hours with the added special condition that you are to receive an alcohol and drug evaluation and complete any treatment as required. Do you understand that, sir?
Yes, ma'am.
All right, thank you. You can go back.
Thank you, Judge.
All right, yes, sir, you can be excused. Mr. Monroe, I see you
Thank you.
joined the call as well on a motion to modify for Stiles. Deputy, is Stiles up?
Your Honor, Mr. Stiles is not in. Your Honor, Mr. Stiles is not in custody. He was serving weekends in jail, and that was what we wanted to address in my motion.
Okay, so we're just waiting on him to join the call.
Yes, ma'am, and I think he's on the 10 o'clock calendar. We're coming in early in case you get done.
Right, that's great. So whenever he wants to join, then we'll take that. Okay.
Thank you.
Thanks. All right. The announcement in Joe Summers.
I think that's Ms. Farrar's
It
case.
is. I was trying to unmute my computer. Your Honor, that's a stip as to the violations, and we'd like to be heard on disposition.
All right, Mr. Summers can come to the podium. All right, good morning, Mr. Summers. You're here this morning for petition for violation of your probation. For the purposes of this hearing, Mr. Farrar, is he waiving his right to be in my physical presence?
He is, Your Honor.
All right. It is my understanding it's stipulation of violation, but he wishes to be heard on disposition. Is that correct?
Yes, it is.
All right. We'll please place the violations on the record.
Yes, Your Honor. The defendant has new violations of criminal law. On or about 11/13/19, the defendant committed the offense of criminal trespass in Cobb County. On or about 1/3/20, the defendant committed the offense of possession of drug-related objects in Cobb County. The defendant also has new violations of special conditions, failure to report. The defendant was released from Clayton County Jail on 10/24/19 and was told to report to the Morrow office within 24 hours of release. The defendant failed to report as instructed at that time nor any time thereafter and has absconded probation supervision. Failure to pay. The defendant is currently in arrears in the amount of $701. The defendant has never made a payment. Violation of special conditions to attend 2 AANA weekly meetings, submit to HIV testing, get alcohol drug evaluation treatment, and complete 100 hours community service. The defendant has failed to provide any proof of completing any court-ordered special condition. Violation of special condition palm waiver on 4/24/19. The defendant signed a palm waiver to be released back to probation with the added condition to complete an additional 24 hours community service, in which he has failed to do so. This is also the defendant's fourth violation of probation.
Okay. That your understanding is the stipulation, Ms. Farrar?
It is, Your Honor.
I will find by preponderance of the evidence that he has violated his probation. Then what is the state's recommendation?
State's recommendation is 1 year to be revoked to serve in the state penal system. Upon service of time, the balance of probation is suspended and close the case. The balance of time being 1 year, 7 months, and 1 day.
All right. What would you say, Ms. Farrar?
Your Honor, Mr. Summers has been in custody first in Cobb County since January 3rd, and then from there he was released to Clayton County. So he's been in custody, I think, over 8 months now. We would ask that he be terminated on time served. He'll be on probation in Cobb County until January 1st. He can go live with his sister in Ackworth. He can work. He works in demolition, so he can work. That's what we would ask, Your Honor, that you terminate him on time served.
You know, this is your fourth violation, sir. I believe that a year is certainly reasonable, as nothing has essentially been done despite multiple chances. So I'm going to revoke a year to serve. Upon the service of that year, your case will close. You can go back. What's the announcement in Liberace Hayes?
He's my client, Judge, and actually we need the equivalent of a bench conference before we start that case.
Who's representing the state?
That's me, Your Honor.
All right, let me create a breakout room. Stand by. All right, if I can have Mr. Hayes to the podium, I'm going to create a breakout room with he and Mr. Ellis so that he can advise him that that's being removed off today's calendar and the reasons why.
Yes, ma'am.
Give me just a moment, it's closing. All right. There should be an invite, thanks.
Okay.
You want to turn it to
Found it.
because it's blaring in my.
Okay.
Good morning.
Can you hear you?
I don't know.
I heard noise in the background. Ask her if
We
she
can hear you. The judge is handling something else, and they'll be with you in just a second, sir.
I can't.
Hold on.
Volume.
Until it starts. Okay.
I can hear him, but barely.
We can hear you, but bring your camera down a little bit more. It's up like above, cutting your eyes off. Bring.
I can hear.
You may have to unmute.
I can't hear her.
You can't hear me? I can
No.
hear. I can hear you.
What happened?
She said she could hear me.
I got it turned up.
Can you hear me now?
I can. So now hit your
I
mute.
can't hear you.
I can hear you.
It's
Well,
up.
we're
The
going-
volume's up.
Okay, what we're going to do is we'll take care of your matter in just a moment. In the meantime, I'm going to mute you, sir, and then we'll go back. All right. All right, are you ready, Mr. Ellis? Have you had an opportunity to speak with your client?
Yes, ma'am, I have. And I've explained to him as best I could what the problem is, and as well as the fact that I'm going to give him make another video visit request to speak with him immediately, okay?
All right, thank you.
So where is he? I'm sorry, I'm looking at him now. What we've agreed to, Judge, is to continue this matter until I can more fully inform him of exactly what's going on and what his options are.
Okay, all right, great. You can go back, Mr. Hayes. We're just going to remove that off the calendar based on what you've indicated you're going to file, Mr. Ellis. You can go back, sir. Thank you.
No, I don't agree with the teams. I agree with.
Okay. Mr. Hayes, your lawyer has had a bench conference with me. I've indicated I'm not going to accept stipulation based on a competency filing that's going to be filed, so you can go back. He can go back, Deputy. Thank you. All right. Mr. Ellis, we're going to take care of your matters in just a moment. I'm going to take Mr. Monroe's matter.
That's fine.
But we'll have all of your matters done before you need to go to drug court. All right,
Okay,
Mr. Stiles, if you want to unmute, please, sir. Mr. Stiles, if you wish to unmute, there you go. All right. Mr. Monroe, are you ready? And Mr. Stiles, can you hear us?
Yes, ma'am.
Okay. You need to unmute as well, Mr. Monroe. Okay. That's all right. We're here this morning for Mr. Stiles' motion to modify his sentence. For the purposes of this hearing, Mr. Monroe, is he waiving his right to be in my physical presence?
Yes, Your Honor.
All right, go ahead.
Your Honor, Mr. Stiles entered a plea back in February. I believe Carbo was sitting for it to happen, but he's a multiple DUI offender. He entered a plea and was sentenced to serve 45 weekends in jail, which he has been serving faithfully. He had a stroke back at the end of June and was in the hospital, and he has a heart condition, and he's been doing his counseling and doing everything he's supposed to do. We spoke with probation, and they told him that he could, because of the high, he's very high risk for the COVID situation. So we spoke with probation. We had a doctor's excuse from his doctor for him to hold up on the weekends. What we're court to do is to consider spending the weekends. I think he's done about 26 weekends so far. He's probably got about 14 left. But because of his health situation, we would actually consider suspending the balance of his weekends. Also, I would like to point out that since probation told him he didn't have to do those weekends, he's completed 40 hours of community service towards the 480 that he's sentenced to. So we're just asking the court to suspend the balance of his weekend.
All right. What says the state?
Your Honor, the state would object to any modification of this sentence. This is the 10th DUI conviction in this defendant's history. This was a very fair sentence. If he's not even required to stay in the, I'm hearing some feedback, I'm sorry. Can the court hear me?
Yes, I can.
Okay, thank you, Judge. He's not being asked to remain in the jail, in the detention center consistently. He gets to leave, go home, take care of his health situation, and then he only has to come in on the weekends. I'm concerned, Judge, the state is concerned about him having his sentence suspended at this point because of his prior convictions, because of what this sentence was based on in the first place. And as Your Honor can see, there just isn't any alternative sentence that is really being offered by the defense counsel that is reasonable given this situation. I got to mention, I don't know if I see alcohol bottles behind him on the fireplace, but I just want to remind him. Okay. Thank you, Judge.
Thank you. Who is supervising him with probation?
Officer Daniels.
Who is not present on the call. All right, Mr. How much longer?
I just read through his notes, Judge.
Okay. Has there been any petition for any violation since February?
No, Judge, and he just completed 44 community service hours. Not physically doing it, but we just had a back to school project in which he participated by buying back to school items and stuff of that nature.
All right. What about as it relates to, how long is his sentence?
Your Honor, it's 5 years.
5 years. All right. It's your motion, Mr. Monroe. Anything further?
No, Your Honor, we were just asking the court to consider suspending the balance of the weekends. It's just really dangerous. I mean, it could be a death sentence soon if he catches the coronavirus while he's in there. His health is not good. And he has not missed a weekend. He's done everything he was supposed to do as far as probation. He's got plenty of time left. If he violates, he knows he's going to jail.
All right, so this is what I'm going to do. I'm not going to suspend the balance of the weekends, but I will not at this point require him to continue serving them while there is an existence of a judicial emergency order in this state. So during the pendency of the judicial emergency order, he will not be required to serve his weekends. Upon the expiration of that judicial emergency order, unless further ordered by the court, you were to resume serving those weekends. So Mr. Monroe, and that includes either a statewide judicial emergency order or if our local jurisdiction extends that judicial emergency order. So can you draft an order to that effect, Mr. Monroe, and send it?
Do I have to do it today?
No.
Yes, ma'am. I'll get it done.
That's fine. And so, so just so you understand, sir, I'm not suspending your weekends, but based on the medical documentation, during the pendency of this judicial emergency order, you're not going to be required to serve them. But as soon as that's up, probation will be notified and you'll have to go back to serving them unless your attorney says otherwise. So if you need to discuss any of that further with him, Mr. Monroe, you can do so offline of the call. So that's the order and judgment of the court.
May we be excused?
You may be. Thank you.
Thank you.
Okay. It's only 10. What's left for you, Mr. Ellis, from the 8? What about James McDonald?
That's been resolved through consent or waiver.
All right, that's a consent waiver.
Yes, two cases, Judge. Yes.
On both of them. All right. We're going to come back to your matter in just a moment, Ms. Farrar. I'm trying to get Mr. Ellis to drug court. What about Everett Stinchcomb?
Yes, ma'am. That's going to be a stipulation in part, Judge, a denial in part to the technicals. We're ready to go forward.
Okay. Is the state ready?
Yes, Judge.
All right. He can come to the podium. That's going to be, hang on one second. Let me scroll back up. It's going to be Mr. Stinchcomb can come to the podium. Thank you.
Judge, I was speaking with Mr. Stinchcomb on the phone yesterday. Unfortunately, we got cut off. It very well may be a full stipulation. Not a full stipulation, but a stipulation to all the technicals.
All right. So do you want me to create a breakout room?
If you could do that, I think it would take me about 30 seconds to get the answer.
All right. There you go. All right, Mr. Ellis, what's the announcement? You need to unmute. You need to unmute, Ken.
We're going to stipulate that all the technical judge will have to be heard on disposition only.
Okay. All right. Good morning, sir. You're here this morning, Mr. Stinchcomb, for a petition for violation of your probation. You're represented by Mr. Ellis as your attorney. Mr. Ellis, for the purposes of this hearing, is he waiving his right to be in my physical presence?
Yes, ma'am, he is.
All right. And it's my understanding it's the stipulation as to violation and which to be heard on dispo. All right.
Yes, ma'am.
Go ahead.
The defendant has violated the terms and conditions of probation in the following particulars. He has failed to pay, and the defendant is currently $235 in arrears on court-ordered monies without ever making a payment. He's failed to avoid injuries and vicious habits, and that the defendant tested positive for methamphetamine on or about January 24th, 2020. He's failed to notify probation of address change. On May 27th of 2020, a field visit was conducted at his last known address of record and was advised that the defendant did not reside there. The defendant's whereabouts were unknown. He has also violated the special conditions to enter and complete the day reporting center, in that the defendant has failed to enter the day reporting center. Also, just for the purposes of this hearing, we'll be withdrawing the criminal law violation.
All right. Is that your understanding of the stipulation as to violations, Mr. Ellis?
Yes, ma'am, it is.
All right, then therefore I will find by preponderance of the evidence that he has violated his probation. What's the state's recommendation?
To revoke 12 months and restore to probation. Once he's released, he's to report to probation in 24 hours.
All right. Mr. Ellis, what would you like to say on behalf of your client?
Okay, Judge, Mr. Stinchcomb was in a very serious automobile accident, or at least a car struck him. I believe it was on January 28, 2020. And as a result, he became hospitalized initially, I think, for about a week. But subsequent to that time, he's had to go back or return to the hospital on at least 2 occasions. He was readmitted on both occasions because of the injuries that he's received. As a result, he wasn't able to begin his tenure in the Clayton County Day Reporting Center as he had been ordered to do. He understands that. In addition, he has been charged with failure to maintain or failure to keep the probation department aware of what his address was. He did actually do that, and he can explain this as well. What happened was his condition physically, medically was so tenuous that he had to move in with his daughter who lives in Clayton, in Carroll County. His daughter at that time was a student at the University of West Georgia. He moved in with her to that location, but he did appraise of the Department of Probation about this. So there was no just absconding without them knowing where he was. He did tell them that. Now we admit to the failure to pay. He wasn't able to work during this time, and we admit that back in December he did test positive for an illegal drug being in the system. That much we don't contest at all. But the failure to enter the Clayton Day Reporting Center was a direct result of what his medical condition was at the time. He had been injured approximately a week or so prior to the time that he was supposed to enter that program. He still suffers from these injuries. I mean, he can explain his injuries to you. He suffered just severe lacerations, had to have staples put in his body, was rendered almost incapable of taking care of himself physically. He just couldn't handle anything about his not very much about his personal care. And the same as I said, is what led to his inability to reside where he had been residing before. He had to move in with someone who could take care of him. That was, in fact, his daughter in Carroll County, but he did tell the probation office about that.
All right. So what are you asking?
I'm sorry?
So what are you asking for? The state's asking.
I'm sorry. Judge, what we would ask for is time served in this case. I'm sorry.
All right. I'm going to revoke 6 months to serve, and then upon the service of that, he will return to his original order of probation.
Judge, would that include DRC or that takes away the DRC?
That takes away the DRC.
Okay.
Thank you. You can go back.
Okay.
All right. Good morning, Mr. Tolles. You've joined us for an arraignment this morning. Let me pull up your client's name. Mr. Wathel can come out. Good morning, Mr. Tolles. If you can unmute and join us, please. Thank you. Good morning. Mr. Wathel is here for an arraignment, or Wathel is here for an arraignment this morning. Is he waiving his right to be in my physical presence, Mr. Tolles?
Yes, Judge, and I apologize. I got 2 Zoom courts going on at the same time. So
You're all right.
You're
fine. So are you entering a not guilty plea on his behalf and waiving formal arraignment?
Yes, we are entering a not guilty plea, waiving formal arraignment. And I also the reason why I wanted to be present today, Judge, was that he had a probation matter, which was before Judge Carter. He has admitted to that probation violation. And so when he has resolved this case, we want everything resolved, and Judge Carter wanted that to happen. So unless there was some objection from Your Honor, that we wanted to have everything handled here, the VOP and the new case.
That's fine. Just get with probation in the state, and then we'll take care of it as soon as you guys reach a resolution.
I have the case, Judge. So whenever they have a resolution, we can negotiate.
So, I would say about maybe 30 days, we can come back and probably resolve the situation.
All right, I'm just going to take it off the calendar, and you just let me know when you guys have resolved it, and we'll put you on a Friday.
And Your Honor?
Yes.
I just wanted to let Mr. Tolles know that he can contact me. I'm the prosecutor on the case.
Great.
All right. May I be excused?
You may be.
Thank you.
Thank you. All right. All right, so Mr. Ellis, that leaves you with Mr. Gilbert, Kedry Gilbert.
Yes, ma'am. I think he's my last one, I believe.
All right, and what's the announcement now?
Judge, I received an offer on his case subsequent to talking to him yesterday. If I had to explain this to him, I think we're going to be able to stipulate.
All right, Mr. Gilbert can come to the podium, and I'll create a breakout room.
Okay, thank you.
Your Honor, in the breakout rooms that you're creating, Courtney and I aren't getting into the same one as Dr. Ellis.
Okay, didn't realize you guys wanted to go with him. I'll add you.
Thank you, Your Honor.
right, Mr. Ellis, what's the announcement?
This is going to be a full stipulation, Judge.
All right. Is he waiving his right to be in my physical presence for the purpose of this hearing?
Yes, ma'am, he is.
All right. The state, please place the violations on the record.
Yes, Judge. The state is going to withdraw the criminal law violations for the purposes of this hearing, but the defendant has violated the terms and conditions of probation in the following particulars. He has failed to pay as ordered, and that the defendant is currently $1,972 in arrears of court-ordered monies, making his last payment of $64 on January the 7th of 2019. He's violated the special conditions to show proof of employment and complete theft prevention treatment, and that the defendant has failed to show proof of employment or treatment.
Is that your understanding of the stipulations to violations, Mr. Ellis?
Yes, ma'am, it is.
All right, I will find by preponderance of the evidence and that he has violated his probation. What is the state's recommendation?
To revoke 30 days and restore him to probation. He's respond to probation within 24 hours after release.
All right. So I'm going to revoke 30 days to serve. Upon the service of that 30 days, you are to return to the original order of probation and report within 24 hours. The sheriff will calculate your 30 days as he is allowed to by law. Anything further, Mr. Ellis?
No, ma'am.
All right, he can go back. All right, Herman Henderson can come to the podium. That's Ms. Farrar's. I believe you're finished, correct, Mr. Ellis?
Yeah, I think that's both the 8 o'clock and 10 o'clock calendar for me.
It is. It is.
Okay.
So have a good weekend.
Okay, thank you.
Don't say I'm supposed to have 4. I didn't be up there. He's my attorney also.
We can have Henderson to the podium, please, Deputy. All right, and if you guys can unmute, thank you. Good morning, Mr. Henderson. You're here this morning for formal arraignment on your charges. You're represented by Ms. Farrar as your attorney. Ms. Farrar, is he waiving his right to be in my physical presence?
He is.
All right, and what about his arraignment? Are you waiving formal arraignment and entering a not guilty plea?
We're waiving formal arraignment and have actually entered into a negotiated plea with the state, Your Honor.
Okay, all right, so this is a plea. Sir, if I can get you to please raise your right hand. Do you swear or affirm the evidence and testimony you're about to give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Sir, what is your true and correct name?
Herman Marcel Henderson.
All right, give me just one moment, Mr. Henderson. Sir, you're charged in this accusation with 5 counts. What is the state proceeding on?
All 5 counts, Your Honor.
In count 1, you're charged with theft by taking. They allege you committed that offense on April the 1st of 2020. In count 2, you're charged with theft by taking. They allege you committed that offense on March the 19th of 2020, as well as burglary in the 2nd degree and theft by taking, or burglary in the 2nd degree on the same date. And then in count 4, you're charged with theft by taking. They allege you committed that offense on March the 14th of 2020. Do you understand what you were charged with?
Yes, ma'am.
Are you represented by Ms. Farrar as your attorney?
Yes, ma'am.
Have you had an opportunity to discuss these charges with her?
Yes, ma'am.
You taken the time and opportunity to counsel you and advise you concerning your rights and options with respect to these charges?
Yes, ma'am.
Are you satisfied with the advice and counsel that she has given you?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to the charges?
Yes, ma'am.
In fact, have you signed, or in fact, do you intend to enter a guilty plea here this morning?
Yes, ma'am.
Do you understand that if you pled not guilty, you would have the benefit of all of the following rights, including the right to a speedy and public trial by jury, the right to see, hear, and cross-examine any witnesses that the state will call to testify against you, the right to use the power and process of the court to compel the attendance of any evidence on your behalf, or to compel the attendance of any witnesses on your behalf, and you would have the right to require that the state will prove your guilt beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
You understand that by pleading guilty, you give up all those rights this morning.
Yes, ma'am.
Ms. Farrar, did you go over these rights with your client?
I did.
Are you satisfied that he fully and completely understands each matter as it applies to his case?
I am.
Do you know of any reason why I should not accept his plea?
No, Your Honor.
Sir, are you a citizen of the United States?
Yes, ma'am.
How do you intend to plead?
Yes.
Has anyone threatened you or coerced you in any manner to force you to plead guilty against your wishes?
No, ma'am.
As you stand here today, are you under the influence of any type of intoxicant?
No, ma'am.
Will the state please provide a factual basis?
Yes, Your Honor. On 3/14/20 at 4552 Old Dixie Road, room 319 in Forest Park, which is located in Clayton County, Georgia. The defendant entered the room of Anthony Goodman by forcefully breaking the window and opening the door. The defendant then took a television and car keys that were located on the dresser. He did not have permission to be in the room. The defendant is then seen on videotape driving away in the victim's 2007 Ford Taurus valued at $1,500. He did not have permission to take the vehicle. On 3/19/2020, located at 16 Forest Parkway, Shed 26 in Forest Park, located in Clayton County, Georgia, the defendant entered Solace Produce inside the State Farmers Market without permission. He removed keys to a 2009 Chevrolet Express van and a bottle of Crown Royal. The defendant then used the keys to steal the van, valued at $11,000. The defendant was identified on video. On 4/1/2020, located at 16 Forest Parkway in Forest Park, Georgia, located in Clayton County, which is the State Farmers Market, the defendant, without permission, got into a 2004 International truck, the property of Vista Produce, using keys that were left in the driver's side door panel. The defendant is observed on video leaving the incident location in the truck. The value of that truck was $50,000. In all three incidents, the vehicles were recovered at 241 Falcon Drive, which is the Economy Hotel, where the defendant was staying. He was also observed on hotel security camera exiting each vehicle. None of the vehicles were damaged as a result of these incidents. All three vehicles were recovered.
All right. Is this a negotiated plea?
Yes, it is, Your Honor.
What are the terms?
The terms, the recommendation would be on counts 1, 2, 3, and 5, 10 years to serve 3. Theft class, a stay away from all 3 incident locations, $1,000 fine, attorney's fees, probation fees, and a Fourth Amendment waiver. That to run concurrently, again, with count 1, 2, 3, and 5. And then count 4, 12 months probation, also to run concurrently with the other counts.
Well, that'll have to be 12 months to serve, but if it's a 10 serve 3.
Sorry, yes, Your Honor.
Run concurrently. Is that your understanding of the state's recommendation?
Yes, ma'am.
It is, Your Honor.
Anything further you'd like to add on behalf of your client?
Yes, Your Honor. He was recently before Judge Mason. I don't have the date written down, on a probation where he was revoked for 5 years. And we would just ask that this sentence run concurrent with the violation.
All right. Sir, I will accept your plea. As to counts 1, 2, 3, and 5, it'll be 10 years to serve 3, the balance probated. Theft class, stay away from each incident location, $1,000 fine, attorney's fees, probation fees, and a 4A waiver. As to count 4, that'll be 12 months to serve, to run concurrently with counts 1, 2, 3, and 5, and they will also run concurrently with one another and concurrently with any sentence you're currently serving. As to counts 1, 2, 3, and 5, you have 4 years from today's date to file a habeas corpus petition in this matter, and as to count 4 is 1 year from today's date. You also have 30 days to file a motion to withdraw your plea. You can go back with the deputy.
Thank you, Judge.
You're welcome. All right, off of the 8 a.m. calendar. Huh?
He got to stay up for probation to sign him up.
Oh, okay. Deputy, can you have him stay up so he can give his information to probation? Sorry.
Yes, Your Honor.
All right, thanks. If you'll just have him stick around, I appreciate it. Jalen Stewart can come to the podium in the meantime. And I think Mr. Stewart's the last matter off the 8 a.m.
And Your Honor, is it still showing, has he hired a lawyer or?
Mr. Stewart, have you hired private counsel? No, he is not. So do you need to speak
Okay,
to him in the breakout
I
room?
do. I had two appointments and I'm not sure what happened, but I never.
I'm opening it now.
Thank you.
Thank you.
And Judge, you add me just so I can give Ms. Farrar the recommendation, I'm sure to be able to be resolved.
Sure, I'll add you and then you can leave it.
I've got it revoked 3.
Hang on, just go join the breakout room, Ms. Farrar, and I've sent her there so you guys can chat and then she can leave.
Did you add me too? Judge.
There you go. There should be a breakout room invite sent out. Clayton County Court will accept as well. You should have gotten one too, Ms. Blunt. All right, what's the announcement, Ms. Farrar?
Your Honor, it's a full step.
All right. Good morning, Mr. Stewart. As you know, you're here for a probation revocation hearing. You're represented by Ms. Farrar as your attorney. It's my understanding that it's a full stipulation, and is he waiving his right to be in my physical presence for the purpose of this hearing?
Yes, Your Honor, he is.
All right, will state please place it on the record.
Just a quick question for Ms. Farrar. When you say a full stipulation, that means to be criminal law violations as well?
Ms. Stanley,
Okay, okay.
she has a new announcement, I guess, about what.
I got you. I got you. So for the purposes of this hearing, we're gonna withdraw the criminal law violations.
Correct.
The defendant has violated the terms and conditions of probation in the following particulars. He's failed to pay his order, and that the defendant is currently $1,103 in arrears with $1,000 of unpaid restitution on court-ordered monies. He's also violated special conditions to complete theft prevention treatment, and that the defendant has failed to show proof of that treatment.
All right. So your understanding is stipulation is to violation, sir. I will therefore find by preponderance of the evidence that you have violated your probation. What is the state's recommendation?
To revoke 30 days and restore to probation. Mr. Stewart is to report to probation within 24 hours.
Is that your understanding of the state's recommendation, Ms. Farrar?
It is, Your Honor.
All right, I will revoke 30 days to serve. Upon the service of that, you are to return to probation, the original order, and report within 24 hours. The sheriff will calculate that as he is entitled to under the law. You can go back.
Judge, that completes my case, and may I be excused?
You may be. Christopher Witt. What's the announcement on that, Ms. Farrar?
Your Honor, I believe we were coming back on disposition only. He'd already admitted to the violation, I recall.
Okay, is there any additional, Matt, anything additionally that you're going to want to present?
Your Honor, I emailed a copy of his medical records to Andrew yesterday. I emailed them to Mr. McDowell and to Ms. Stanley.
Well, hang on 1 second. Let's get him to the podium first. Can Mr. Witt come to the podium?
Good morning, Your Honor.
Good morning. All right, go ahead, Ms. Farrar.
They do show that he does have heart disease. They don't show the full thing because they don't have the Southern Regional record. I'm assuming that's where he was sent to Southern Regional. We don't have their records of what happened there, but we do know that he was sent there. He says he's been there for 2 heart attacks. I did email Dr. Clopton for his recommendation, but I didn't hear from him, but we're just asking that he, because of his medical condition, that he does need to have a defibrillator implanted, and he's had 2 heart attacks since he's been in jail. He's at risk more than the general population to the COVID virus, and we would ask that he be his probation be terminated and he be released on time served.
Based on the state having an opportunity to review the medical records, does the state have anything additional it would like to say?
Your Honor, I would like to hear the doctor's recommendation. I understand he hasn't been able to get back with Ms. Farrar. Any new recommendation would be dependent on what he would have to say.
All right.
And
how much time does he have remaining on probation? Somebody remind me.
12 months and 5 days, Your Honor.
Okay, I'm going to release him back to probation, and he is to report within 24 hours. But I'm not going to terminate probation at this point with the with what's going on. I'm not going to require him to serve any additional time in jail, but he's going to return to probation until there's any further medical documentation that he cannot report and continue to do what he's supposed to do.
Do I need to bring this, give that to them? And is this going to be, do I report to them in person?
You're going to report to them in person, correct, Ms. Stanley?
Yes, Judge. And are you taking away the DRC requirement, which he doesn't even have enough time remaining to complete the DRC at this point?
No, yes, I am taking away the DRC requirement, but you're going to go back to probation.
So just go to their office tomorrow morning or Monday morning, because it's Friday, today's Friday, so go Monday morning or
Yeah.
go tomorrow. Do they do it on the weekend?
Monday, Judge.
All right, Monday morning, sir.
Okay.
Was that 6 months, the recommendation, Ms. Stanley? I can't remember the last time we were here.
She said she was releasing him on time served, Ms. Farrar.
Oh, okay. But he's still on probation. Okay.
All right,
My done.
you can go back.
Thank you. God bless y'all.
All right, that's all of Ms. Stanley's, correct?
That is correct, Judge.
All right, we'll see. We've got Mr. Dean, and then we'll bring back up Mr. Henderson so Ms. Hardy can interview him. If Mr. Dean can come to the podium.
Your Honor. Okay, he does need to come. Okay.
All right, good morning, Mr. Dean. You're here this morning for an arraignment. Is he waiving his right to be in my physical presence, Ms. Farrar?
He is, Your Honor, but if I could, we thought we had a fast track plea worked out, but it's been withdrawn by the state. So if I could have a moment to just explain that to him in a breakout room.
Sure, give me just a moment. All right, Ms. Farrar, you ready?
We're ready, Your Honor.
All right. So you're here this morning for an arraignment. Is he waiving his right to be in my physical presence for the purposes of this hearing?
He is, Your Honor.
All right. And what does he intend to do?
Not guilty.
All right. And waive formal arraignment?
Yes, ma'am.
All right, sir. Your attorney has entered a not guilty plea on your behalf. You can go back. All right. Thank you. Ms. Farrar, that's all of your business, correct?
It is, Your Honor.
All right. Have a good weekend.
You too, Judge. Thank you.
All right. So Mr. Studdard has joined us early. Thank you, Mr. Studdard, for joining us early. If you want to unmute, then we can take care of your matter in Washington. Mr. Washington present, he can come to the podium.
Your Honor, regarding that case, it's my understanding that
I've signed your bond order. We just have to do the waiver. We just have to do the enter of the not guilty plea.
Well, due to my oversight, Your Honor, One of his charges was administratively dismissed, and that was not reflected in the bond order. So it looks like the jail is requesting a new one. I will do that and have it over to your office this afternoon.
Okay, that's fine. I'm not sure that a new bond order is required when one of the charges has been administratively dismissed, but I believe that a copy of the administrative dismissal that would not be reflected on a bond order. So maybe you can send that over to classifications and handle it in that matter. If not, then of course I can get involved. Good morning, Mr. Studdard. You're here this morning for Mr. Washington. Is he waiving his right to be in my physical presence for the purposes of this hearing?
Judge, let me first of all ask you, can you hear me okay?
I can.
All right, thank you. I'm sorry, I have a new monitor, a new camera and everything, trying to get this thing straight, so I'm ready to go.
That's all right. We can hear you, we just can't see you.
My camera is, the camera
Okay.
is on. I'm here.
Yes, I recognize it. So is he waiving his right to be in my physical presence for the purposes of
He does,
this?
Judge, yes.
And is he waiving formal arraignment and entering a non?
Yes, Judge, he does.
All right. And so Mr. Washington, he has entered a not guilty plea. Mr. Studdard has on your behalf. I've already signed a bond order, and so everybody I think should be set, and hopefully you'll be released at some point today once the jail processes that.
All right.
All right, you can go back, Mr. Washington. Thank you for joining us early, Mr. Studdard. I appreciate that.
Okay.
All right, I believe that concludes all of our Friday morning calendars. You guys be safe.
You too, Your Honor.
Except for Miss Hardy needs to speak to, I swear I'm gonna attempt not to forget it. You need to speak to Mr. Henderson. So, all right, great. Can Mr. Henderson please come to the podium? Everybody else can be excused. And I'm gonna stop the live stream.